I'm sorry, I'm just checking to make sure that we're all here. Is Attorney Baldwin here?
He will not be attending today.
Okay, thank you. Is everyone ready to proceed?
Yes.
Yes, Your Honor.
Okay, I'm having significant problems with my video feed. I'm not getting any video from most people.
I can't see one of the council.
Okay, I just did that fix of going to together mode and then back to
Yeah, I tried
live
that.
mode.
That didn't have. I didn't get any. It wouldn't go back.
It just worked for me. Try it now and it might work for you.
I'm okay. I'll try. Yeah, that worked.
Okay, thank you very much. This is the second matter on today's calendar. This is Gallagher versus the town of Fairfield. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. How we do this, if a justice has questions, they will raise their hand or raise their virtual hand. Once counsel sees that hand, I would greatly appreciate it if you would pause your argument so the justice may ask the question. Does everybody understand that?
Yes, Your Honor.
Thank you very much. Counsel for the appellant, please identify yourself for the record and let me know how much time you need for rebuttal.
I'd like to reserve 5 minutes for rebuttal, Your Honor.
I'm sorry, say again, please.
5 minutes.
5 minutes. Justice Senior Associate Justice McDonald will be our timekeeper. He will show when there are 5 minutes, 3 minutes, and time is up.
Understood. Thank you.
Whenever you're ready, counsel.
Excuse me. Okay, I was just going to remind everybody to mute when they're not talking. Thank you.
Thank you.
Justices, if it please the court, my name is Catherine Krieger and I represent the town of Fairfield. In this matter, the plaintiff, as a disabled retiree, seeks to have this court hold that he should receive the same exact health insurance coverage as active employees of the town of Fairfield, and not the Medicare supplement coverage that he currently has. It is the town's position that the coverage that the plaintiff currently has satisfies the town's obligations under the collective bargaining agreement. The overarching issue in this matter, on both the cross appeals, involves the interpretation of the collective bargaining agreement that was in effect at the time of the plaintiff's retirement, together with the framework for interpretation provided by this court in the matter of Poole versus Waterbury, and by the General Assembly and their enactment of General Statutes 7-459C. General Statute 7-459C applies in this matter and codifies this court's holding in the Poole case that the benefits of a retiree shall not be diminished and are at least equivalent to those previously provided by the municipality. The decision in Poole remains important in this case for two reasons.
Counsel,
First of all,
there's a question from Justice Keller.
yes, Your Honor.
All right, thank you, Chief Justice. Attorney Krieger, what are the active employees paying out of pocket for their insurance right now, or at the time that the case was brought?
They are paying similar to what the plaintiff is paying.
You don't know the exact amounts?
I do not know the exact amounts, and I don't believe it was in the record.
So He's claiming that he and his wife are paying about $500 some odd a month for the Medicare supplement coverage, Part B. Is that what an active employee is paying out of pocket, about $500 a month?
Well, Your
Is
Honor,
there evidence of that?
there is not, and I think it was up to the plaintiff to provide or to show that he was, make a side-by-side comparison to show that he was paying more than the active employees. And as I've argued in my papers, I don't think that he did that.
Because there was like an 80-20 provision or something like that. Is that, so what does that mean, the 80-20? What does that mean?
So the 80-20 provision is co-insurance, and that was what was provided for as one of the benefits in the original collective bargaining agreement. There no longer is co-insurance.
All right, now my final question is, where does the Ms. Lynch, was it Ms. Lynch who did this? Where does she get the authority to sign up the plaintiff and his wife on Medicare?
That's an authority that she has as the benefits manager for the town of Fairfield.
The town gave her that authority, or does the federal government give her that authority?
The federal government recognizes that authority.
In under what regulation or statute or rule?
I don't know. The plaintiff has argued that the town does not have that authority, but they have not set forth any regulation or statute that says that the town cannot do that. And obviously the federal government recognized that authority because they switched the plaintiff to Medicare.
Having just gone on Medicare and having had to do all the signing up myself, I wish our HR people would sign us up instead. Thank you. Thank you.
So as I was saying, the decision in pool remains important for two reasons. First, it recognizes the competing and significant policy concerns between.
Counsel?
Yes.
Sorry to interrupt you, but there's a question from Justice Kahn.
I'm sorry, I didn't see that.
Thank you, Chief Justice Robinson. My question, counsel, is a follow-up to Justice Keller's question. I know that the plaintiff or appellee here did not submit this to the trial court, and I'm not sure if we could even take judicial notice of anything of the sort, but do current police officers on the force as municipal employees pay a portion of their insurance? In other words, is there a split? Some employers pay 90% of the premium and the employee pays 10%. Sometimes it's a 70-30. Do they currently pay a portion of their premiums?
I don't know that. It's not specifically in the record, but Cheryl Lynch, the benefits manager, did testify that the Medicare supplement plan is designed to mirror the plan for the active employees. So based on that testimony, I have to say they do not pay in.
Meaning the city pays 100% of their insurance premiums?
So the town is self-insured.
Okay. Okay. Thank you. Sorry.
So there are competing policy interests between the town and its employees and retirees. For the municipality, as Poole states, there is an interest in predicting and controlling the costs to ensure the fiscal integrity to provide benefits not only for retirees and employees, but also to continue to be able to provide services for town residents. And as I mentioned, the town is self-insured, so those cost considerations are very much in the forward. For the employee, in this case, the plaintiff and retiree, the promise of health insurance may be a significant inducement for determining employment. And so it's important that the town's promise be upheld. Yes, Your Honor.
Thank you, counsel. There's a question from Justice Doria and Justice Keller.
Yes.
Thank you. And I think it's repeated in a couple of places in the briefs, yours and maybe your opponents.
Justice
You
Doria, you're muted.
Sorry, I thought I just clicked off on it. So that was a really good question. I'm not sure I can repeat it. I'm kidding, for the record. There are a couple of times in the briefs, and I'm going to read from the trial court's decision. It's mentioned that the trial court says the town insists that federal law mandates that the plaintiff enroll in Medicare when he attains the age of 65. That sounds right. That sounds elementary, but I don't see anything in anybody's briefs or in I mean, is there like a statute that says that? That seems pretty fundamental. If that's right, I mean, I take it your point is we're powerless to do anything else. And where does that come from?
It wasn't in the record, Your Honor, and in my search, I didn't find it. However, it was a finding by the trial court, as you mentioned.
But if it's a federal law, okay, you just don't know?
I know that the law requires that active employees or active, that an employer cannot require an active employee to move to Medicare when they turn 65. But I believe it's silent as to retirees.
Thank you. Justice Keller.
Thank you, Chief Justice. Attorney Krager, the collective bargaining agreement, in effect, when he retired, promised him that he wouldn't see any reduction in benefits or coverage, correct?
Yes.
It doesn't promise him it won't cost him more as time goes on, does it?
It does not, and the pool decision says that cannot be a reason to require the same benefits.
Okay, now in terms of everyone being required to go on Medicare, I don't think that's true because I know for a fact that judges who retire at 70 continue to be able to stay on whatever state health plan they have, and they're not required to make Medicare their primary coverage. I was, because I'm not on the state plan. I'm on a different state plan that has different requirements. So I think it depends on whether you need to go on Medicare or whether you have guaranteed other coverage that is better. But I don't think there's a federal requirement that everybody over 65 be on Medicare who's retired. All right, thank you.
The second reason that I think the pool decision is important is because this court held that although a retiree has a vested right to medical benefits generally, and we just discussed this, the retiree does not have a right to the specific benefits prescribed in the collective bargaining agreement. The court further stated that a retiree, such as the plaintiff, must demonstrate that the changes to benefits brought their benefits below a level reasonably commensurate with the coverage that they had enjoyed before. And it is not enough for the plaintiff to demonstrate that the changes have resulted in increased payments. In this matter, the collective bargaining agreement was drafted over 30 years ago, and it was impossible for the town and the plaintiff to predict the massive changes in the healthcare industry as well as the health insurance industry. And Much of this change, I think you'll agree, has been driven by the exponential increases in healthcare costs over that period. It's with these considerations that the collective bargaining agreement and the facts in this matter need to be examined. First, I'll submit to you that the collective bargaining agreement does not require that the plaintiff receive the same town health insurance coverage that the plaintiff claims. The benefits that are to be provided to the plaintiff are the same as those in Section 1 of the collective bargaining agreement, which are provided to active employees. But the collective bargaining, yes, Your Honor.
Counsel, sorry to interrupt you again. There's a question from Justice Ecker.
Yes, Your Honor.
Thank you. I just wanted to clarify something. I think it may have been my misunderstanding, but it follows from a colloquy that you had with Justice Keller. So what you're saying is that notwithstanding the assurances in the collective bargaining agreement and in pool and in, I guess, General Statute 7459C, that there's no assurance to the beneficiary that that they won't have to pay more for the same benefits. And if that's true, then really what benefit does the employee get at all from any of these assurances? I mean, if it's basically saying, look, these, you know, we'll provide you with the same benefits, but you're going to have to pay for them, then I mean, it's not really insurance, is it?
Well, I think in pool, the court looked at the balancing of the benefits. You know, costs are going up, so you can't expect that the cost, some of those costs will not be passed on to the retiree. It's a matter of, are those benefits still made available, and what obligations is the municipality satisfying?
But I mean, the benefits are defined, at least in this CBA, in terms of the cost to the individual. You know, there's caps, there's deductible amounts, and so forth. So it just seems to me that, and again, I must be missing something, that the cost of the benefits is integrally tied to the benefits themselves. That's what the benefits are. Is it's inherent in the cost limitations. You know, you only have to pay 20%. You know, of the copays, et cetera, whatever those benefits are.
So
I just don't get the point that there's no. I don't get your response to Justice Keller, that there's no assurance that the costs are going to stay commensurate.
I think that you have to look at the benefits as a bundle of benefits. So that includes the deductible, the coinsurance, if there is any, lifetime maximum, copays, premiums. So for example, the original collective bargaining agreement had a deductible of $100 per individual and $200 per family. It also had a lifetime maximum of $1 million. Currently, the plan has a deductible for prescriptions of $100 and no deductible for anything else, and there is no lifetime maximum. So you're balancing the costs, I think, between the municipality and the retiree.
How does the new requirement of I mean, I don't really know exactly how the Medicare fits together with the health coverage, but it sounds like it's an additional obligation on the part of the employee to now pay that extra amount before getting any of the benefits. And I don't know, that just seems to me to be sort of different. And it's an add-on that wasn't contemplated in 86. So I don't quite understand why it's permissible.
I think that the court has to take a flexible approach and again, look at the benefits in their entirety. So, going back to the original collective bargaining agreement, it had co-insurance 80% to the municipality, 20% to the retiree. There is no co-insurance anymore, so that's gone. Now the town, for costs that the plaintiff incurs that are not paid by Medicare, the town will pick those up. And Ms. Lynch gave testimony to that effect during the trial. So I don't think it's an additional burden for the plaintiff to contribute as the plaintiff did under the original collective bargaining agreement, but now in paying for the Medicare supplement premiums.
So is the problem here that we just don't have an accounting? I mean, for example, they're saying, well, we have to pay an extra $6,000 a year in premiums. And you're saying, yeah, but you don't have that $2,000 maximum deductible. I mean, and that no one sort of did an accounting to see whether ultimately it's a even trade-off. Is your claim is there's a problem? It's a problem with the plaintiff's proof, and they have to live with it.
Yes, essentially, yes. The furthest that went was with the testimony of Cheryl Lynch when she testified that the plan for the active employees mirrors the Medicare supplement plan.
Justice Zachary, you have any more questions?
No, thank you.
Thank you, Justice Keller. And then Justice Kahn.
Thank you, Chief Justice. You just said the town will pick up costs not paid by Medicare, but the
Yes.
supplemental Part B is not paid by Medicare. You have to pay that. So my question is, if he didn't sign up for Part B and only signed up for basic Medicare, would he be getting the same benefits and coverage that he got at the time that he retired? Or would he be getting the same benefits and coverage that current employees are getting? Because I'm trying to understand why the trial court judge ordered you to pay the supplemental premiums.
I think the trial court judge effectively found or decided that those premiums were not part of the benefits. And I think that's where the trial court erred, obviously, because I think that you have to look at those all together. As I was saying, the overall picture of the benefits provided, the costs that are incurred by each party.
But if basic Medicare doesn't give these people what the current employees receive in way of coverage, then in order to provide that to them and make them use Medicare, wouldn't it be fair that you pay the supplemental premium?
I don't think so, because that would put all of the burden on the town. And I think under the original collective bargaining agreement, the cost was shared. Granted, it's more on the town. The town has more resources, but it was shared and it was developed to be shared by the employee.
Anything
All right,
further,
thank
Justice
you.
Keller? Thank you very much, Justice Kahn.
Thank you, Chief. Counsel, I guess I'm a bit confused now. I'm trying to understand your argument. So let me first just tell you what I think you're arguing, and then you can correct me if I'm wrong, and then I have a follow-up question to that. As I understand it, the trial court said agreed with you, your client, that the insurance that the plaintiff or petitioner appellee here is getting is the same in essence as the insurance he would have had or benefits he would have had if he was still under a full employee insurance benefit. But the court went on to say you have to pay his Medicare premiums. Forget the supplement. You have to pay the Medicare premiums. As I understand, your argument is the trial court got it right in terms of the same benefits. By the way, you have 3 minutes left on your argument, in case you weren't looking at the screen. So your position is the trial court got it right when it came to looking at the insurance they now have with the supplement and Medicare and the insurance he would have had if he had not gone on Medicare. The benefits are in essence the same, but ordered your client to pay the Medicare insurance premium. And are you saying that because you now no longer have a cap and you don't have he doesn't have a deductible, it ends up in to be the same benefit that he has to pay for supplement? But when someone pays for supplement insurance and they have a $2,000 deductible, they're hoping they don't have to use it, right? Or if somebody's not on a supplemental that has no deductible, people take insurance and they take risks. So is that comparing apples and oranges? In other words, is a benefit of you no longer have a deductible necessarily equate with paying a certain additional amount? Because you may want to pay less in a premium and take a risk of a deductible. So is it fair to compare those two, whether you're paying more, but you're getting this additional benefit? If you don't use the services, you don't reach the deductible. Do you see what I mean?
I do, but I think you have to consider all of the costs that go into that coverage, because as we've discussed, the benefits under the original plan, deductible, co-insurance, lifetime max, co-pays, it has changed over those 30 years. So you can't expect it to be an exact apples to apples match. You have to be flexible enough to consider all of the costs that are expended by both parties.
So your position is you can offset additional costs to the retired post 65 employee against the fact that if he had been employed, the plan he would have had maybe to pay more if he used the services. Is that what you're saying?
Yes, Your Honor.
Okay. Thank you.
Thank you, counsel. I believe that's the end of your time. Counsel, Attorney Ward, are you ready to proceed?
Yes, I am, Your Honor.
Whenever you're ready, counsel.
Good morning, Your Honor. May it please the court. My name is Bill Ward. I represent James Gallagher, who was the plaintiff at the trial level in this case. And while this is a case about retirees' medical benefits, to be clear, Mr. Gallagher does not believe it is just a case about retirees' medical benefits. It's about Emmett Hibson, the town's personnel director, his abuse of power, and intentional decision to ignore this collective bargaining agreement, ignore the law, and force my client to Medicare, which resulted in the premature death of his terminally ill wife. So for him, this is a big issue. He wanted what the collective bargaining agreement provided. He wanted the coverage he received for 31 years after his retirement. He wanted the coverage he continued to receive even after he turned 65. The only thing that changed was Emmett Hibson became the personnel director, breached the collective bargaining agreement, and unilaterally and illegally forced him and his wife to Medicare Part B. Yes, Your Honor?
Mr. Ward, this is just a curiosity for me, but Was the union ever brought in? So we're talking about the determination of what the collective bargaining agreement meant. Were they ever a party to this?
No, Your Honor, and I suspect I know why, because I've dealt with this in other particular cases. Unions represent active employees,
Yes.
generally speaking, and so
Familiar
they
with that.
don't come in on retiree cases, and I've had other retiree cases that actually wound up in court, and that was the same issue that was arising.
Yes.
Retirees covered by the collective bargaining
Yeah,
agreement.
I'm familiar with that. It was just in this particular situation where you're asking them to asking the court to interpret what a union collective bargaining agreement means. It seems to be a little different spin on that, but please continue with your argument.
The only reason I would suggest it's not is a collective bargaining agreement is exactly that. It's a contract between the employer and the employees, or the former employees, especially as it relates to retirees' benefits. Now, I'm going to start with what the court properly found. They properly found that they had to reimburse them for the supplemental Medicare premium. The plaintiff retired on October 9th, 1986, under a collective
Mr.
bargaining.
Ward, sorry to interrupt you, but there's a question from Justice McDonald. Very sorry.
I've got to work on this. It's a new format for me. I apologize.
We're all working on it, Counselor. Don't worry about it. So my question, though, is your client retired 31 years ago?
In 1986, October 9th.
So I understand the argument he's entitled to the same benefits and coverage. Is he entitled to no adjustment in fees paid over a 31-year period of time?
No, Your Honor, and that's a mistake that was presented by the appellant here. Essentially, if you look closely at the contract that he was provided with, he is actually, and this is where the trial court erred, entitled to the same town-paid health benefits as their active employees, also provided in 7459C. The reason I say that is 459C specifically provides that it allows the town to change retirees' benefits unless he's covered by a collective bargaining agreement that specifies the employee is entitled to the same health insurance provided to active employees. And that is exactly what we have here. This is why Mr. Gallagher never complained for 31 years as the town continued to change its health plan. I see another question. Should I continue my answer? Or
Let me finish answering that question, and then we'll go to Justice Kelly's question, Counsel. Thank you.
Thank you. I mean, that's exactly why he never complained over the 31 years when they kept changing health plans, because he was entitled to the same health care that the active employees were getting. So when they changed it for the active employees, they also changed it for Mr. Gallagher, and he understood that.
Thank you.
I'm sorry, there was another question.
Justice Keller?
Thank you, Chief Justice. Attorney Ward, he's not entitled to the same health care coverage. He's entitled to the same coverage and benefits. It doesn't necessarily have to be the same insurance company. Isn't that correct? So if the active employees have Anthem and they can purchase something that provides the same coverages and benefits without giving their retirees Anthem, aren't they able to do that under the statute?
Not under the statute, because 7459C says, it specifically specifies that the town can only change it, they can change it unless the town is covered by a collective bargaining agreement that specifies employees entitled to the same health benefits.
All right, but this bargaining agreement doesn't use same health insurance benefits. It says same coverage and benefits.
Their contract actually does provide for the same coverage as active employees. And it's a little difficult to interpret, but it's there. Under Article 9, Section 7, it says employees, and it's at A48 in the record, it says employees with retire under the disability provision of the retirement plan and their enrolled dependents shall be entitled to town-paid health insurance as provided in Section 1, ABC, Section 2, Section 3, Section 5, and Section 6. The first part of Section 1 of Article 9 details and specifically states active employees shall receive this. So it is the same insurance as active employees. And when the town gave the active employees or changed the active employees insurance, they were allowed to change Mr. Gallagher's, which is why he never pursued this when they changed plans several times over the years. Obviously, insurance would change, and the contract anticipated that. It provides him with the same insurance as active employees. And that's what he received for 31 years, even after turning 65. There is, and going back to your original question, I believe it was you that raised it. It may have been Judge Doria which raised it, but said, is there a federal mandate? There's not a federal mandate. That's why the briefs are silent. There is not a federal mandate. There's no such law that says he has to be forced over to Medicare. What that was an Emmett Hibson assertion at trial while he testified. There was nothing to back that up. And in fact, Mr. Gallagher wasn't on Medicare Part B until Mr. Hibson sent him a year after he turned 65 and right after he got appointed saying, we're forcing you over. And then he had his benefits manager illegally sign for him, sign for my client. I mean, there is no doubt that's not proper. I don't know where that comes from, but if you look at what Ms. Lynch testified to, she said Emmett Hibson told her she could sign for him. That section, there is an employer section, and then it's turned over to the employee, and it requires the employee's signature. And this isn't a signature to acknowledge receipt of some disciplinary action. It's not a signature to acknowledge receipt of an interoffice memo. This right above his signature says this document has severe consequences for Mr. Gallagher. Rescission of coverage, a non-payment of claims, legally binding him to a subscriber agreement, binding him to pay for Medicare premium supplements. This is all stated right above where Mr. Gallagher was supposed to sign, and he didn't sign it. Cheryl Lynch.
All right, but what difference does that make? Because if he didn't sign it, they wouldn't have given him any coverage.
And then
he didn't follow their new rule. Okay, so I don't understand what the claim is all about, whether she signed it or he signed it. If she hadn't signed it, they wouldn't even have been on Medicare, and the town probably would have said, you've got to go on Medicare or you're not going to get any insurance because that's our new plan for retirees. Okay, so tell me what the trial judge's thinking was in justifying that the town should pay the benefits. Was it because they are paying more than the active employees because they have to pay for the benefits? And by the way, Medicare takes that right out of your Social Security check. So they don't even send you a bill. They take the cost of that supplemental insurance right out of your check. So if you're supposed to get $1,500 a month in Social Security, you're only going to see $1,000 check in the end, because the Part B, and I guess there's no Part D here, which would be prescription coverage, but the Part B, they take it right off the top. So in other words, what was his justification that in order to make what they were getting equivalent to what the active employee was getting, they have to pay for this supplemental coverage? Is that right?
I don't think he was trying to make it equivalent. I think what the trial judge did was he said, you have to supply them with the Medicare premium. By the way, police officers don't get Social Security, or this one doesn't, because they have a retirement plan that supplies for them. So they would actually pay it. So essentially what the trial...
Well, Medicare recipients pay for supplemental coverage too.
Correct.
It's not free unless you have a very low income.
So what happens here is what he did was he looked at the two collective bargaining agreements. The one under which my client retired has no language that requires him to switch to Medicare B upon reaching age 65, Medicare A or B upon reaching 65. The town at trial and in their brief tried to argue that subsequent language in the 2010-2013 collective bargaining agreement, which actually does specify and force retirees to switch from town-paid medical benefits to Medicare A or B when they hit 65. So basically they're saying the subsequent collective bargaining agreement is what's going to control. That's not true. You get the benefits under which you retire. You always have. So I think what the trial judge said is the language that the 85-87 collective bargaining agreement controls, and there's no language that forces him to age 65. It was clearly contemplated by the fact that subsequently you changed that in 2010, and therefore you're going to have to pay his Medicare Part B premiums, which is what he did. I think that was his basis for doing that, and I think he was correct in doing that if he was not going to give my client the town-paid health insurance, which is part of my cross appeal.
Anything further, Justice Keller?
No, thank you.
Justice Daria, then Justice Khan.
Yes, Attorney Ward, is Do you agree with your opponent that there's nothing in the record that would let us know what active employees were paying out of pocket so we could do an apples to apples here? Or I don't see any trial court findings on that.
No, there are no trial court findings, but there was evidence in the record as to what my client did. And basically on page 129 of the appendix, my appendix, it says, and essentially the town provided those plans to you and you accepted those. That's correct. And then my question was, okay, while you were receiving those benefits, did you ever pay any premiums at all for the health insurance? His answer was no, sir.
This is you examining your client?
This is me questioning my client. That was never refuted. It was never contradicted by the town.
Okay, but maybe I'm not making the question clear. I thought the point you're making is that your client is entitled to the same benefits as, I'm not going to use the nomenclature right, benefits, coverage, what have you. But if it has to do with what you're saying, you admit that what active employees have to pay would be relevant to your client's situation. And your opponent's saying, we don't have any proof of what that is. I mean, if they're paying a lot, then maybe you're doing better. I don't know that.
Two things. One is we're talking about premiums and benefits. And my client was always willing to pay the benefits, pay the co-pays as the active employees were receiving.
Oh, so you're saying that the collective bargaining contract would never suggest that as active employees are made to pay more, just pay more, share the premium, that your client wouldn't have to do that?
If the active employees were ever made to pay a portion of the premium, of course he would have to do that because he gets the same benefits as the active employees. That's not the case.
Well, do we know that? Do we know, is there proof that they are not paying?
There's a subsequent collective bargaining agreement, 2010 to 2013, which does not require premiums, and that's in the record. And that's what my client said. Not once did he ever pay premiums, and he was on active employee insurance for 31 years.
Okay, thanks.
That in itself, in his testimony, I think would verify it, in the subsequent collective bargaining agreement, would verify that there's no additional premiums, but there were changes in the co-pays as he was always willing to pay those. He wanted the coverage. He wanted the coverage for his wife, who was alive when this started. He begged for that coverage.
I'm all set. Justice Khan.
Thank you. Counsel, you referred us to the record at page A61 to 62, the actual Medicare application signed by Cheryl Lynch.
Yes.
Well, it looks like Cheryl Lynch. And this, I think, relates to and probably illustrates, I think, the point Justice Keller was making in her questions to you. It sounds like that application was attached to a letter that was sent to your client telling him to apply for Medicare Part A or for Medicare insurance, telling him if there was a penalty for late enrollment, the employer would pay for it, referring to the collective bargaining agreement that he is receiving disability retirement under, that once he reached 65, he would have to go on Medicare, and basically telling him, look, we're going to switch you to Medicare supplement plan, whether you file this or not. So my question to you is, I don't really know that it matters who actually necessarily sent it in, but did your client send it in under protest, or did he not send it in and then the town of Fairfield sent it in for him because they had switched him to a supplemental insurance? Or did he do it, as Justice Keller asked you, because he really had no choice? They were going to cut off regular insurance and switch him to supplemental. Do you know? I'm looking at page A60.
I do know, and there is no evidence that that application was ever presented to Mr. Gallagher for his signature. There was no notation on the application that he refused to sign it. And there was no separate document prepared by Emmett Hibson or Miss Lynch for Gallagher stating he refused to sign it. Miss Lynch.
Okay, but that's not counsel. I understand what you're saying, that there's no evidence, but this letter refers to the attached application, right?
Which letter?
A60 refers to the attached application. Doesn't the letter?
I'm trying to see where that says that.
Yeah. To that end, enclosed is a letter of credible coverage and a form for you to submit to Medicare. If Medicare does impose a penalty, please let me know as soon as possible. So it's referring to him getting an application prepared by his employer to submit it.
You're saying at A60, Your Honor?
Yes, the second to last paragraph.
You are correct that in the town has provided coverage and as such there should not be a penalty associated. Then
and a form for you to submit to Medicare. And they say you're going to be moved as of July 1st, so you must enroll with Social Security prior to March 31st. Please ensure that you have enrolled in the Medicare benefits.
A60 was not accompanied by an attached application, and my client was never presented with one, and there was no evidence to that effect. Further, there was a subsequent letter, which is at A26, and basically what that is, it says, this letter confirms that James Gallagher, retiree, has been covered under the town's coverage. The town covered James Gallagher since his retirement, and the town of Fairfield requires that he be moved. So essentially, effective July 1. And
so let me, I just want clarification, counsel. You're saying when your client, Mr. Gallagher, received this letter, there were no attachments to it? Or he never received this letter?
That's exactly how he received it.
Okay, thank you.
And the subsequent letter basically was a threat that they were going to move him July 1, 2017. He did respond, essentially, at some point, I believe. It may have been before that because they weren't responding to him, saying he wants to ensure that he has town-paid health insurance. So what would have been more effective if that were the case, would Ms. Lynch would somewhere on that application say refuse to sign, or get an accompanying document, refuse to sign, something like that. But she didn't do that. She signed binding him to that agreement, binding him to the transfer. And 9 clearly states employee signature. And she did it at the direction of Mr. Hibson, I believe is what she testified to. Your Honor? Did I go
Yes,
mute?
counsel.
Okay, am I okay, or is that any further questions?
Please continue, counsel.
Okay. Essentially, just to sum up, I think the trial court properly found that the town should pay for the Medicare premium only because, one, the collective bargaining agreement from 85-87, which is the controlling collective bargaining agreement, has no language. And I think that was the trial court's basis, forcing retirees to Medicare at 65. Subsequent collective bargaining agreements contain that language. Unless it was just superfluous language on a subsequent bargaining agreement, the town put it there for a reason. They wanted to stop paying retirees after they turn 65.
Justice Keller.
Essentially, the trial court reasoned correctly in their response. I'm sorry, there's a question.
Yeah, I'm a little confused. You say the trial court properly found that the town should pay the supplemental premium, but your real claim is that he should be getting the same insurance that current active policemen get. So you can't have it both ways. You can't ask for the supplemental Medicare payment plus a full insurance plan that's identical to what current employees are on, correct?
I would completely agree with that, Your Honor.
Okay.
If this court
and you also, you put in a lot of bills that you wanted ordered as damages, but isn't it a fact that you put in reports of bills or what they billed Medicare, but you never really put in evidence of what you actually paid out of pocket, did you?
No.
Okay, thank you.
And Your Honor, if I could answer that first question a little more clearly, that's why you asked for different prayers for relief in my prayer for relief. If this court finds that he's entitled to the town-paid health insurance, clearly the Medicare premiums would no longer need to be paid. So if the court upholds the court or reverses the court on town-paid health benefits, then there's no need to uphold the decision to pay supplemental Medicare premiums. Yes, Your Honor?
Justice Mullins.
How would that work exactly? If just assuming for a moment we agreed with you and he's entitled to what the current employees are getting, he's enrolled in Medicare right now, right?
Medicare Part B and A, yes.
So what happens? Does he have to be unenrolled in that officially? Is our ruling gonna deactivate him from Medicare? How would that work?
If this court were to rule that he were to receive the same town-paid health insurance as defendant's active employees, he would no longer be eligible for Medicare Part B. The town would be the primary, and essentially our damages would be limited to the premiums he's paid since they forced him there until your decision. And that's
that
why.
Simple? Is that simple? If we ruled in your favor on the question of whether he gets the same benefits as the employees, it's that simple. It sort of just happens by operation of laws with our ruling.
It is that simple. If the town voluntarily put him on town-paid health insurance tomorrow, he wouldn't be eligible for Part B. He would not enroll in Part B, and we'd be done.
Okay.
So essentially, Your Honors, to sum up my position, I believe the court did properly find supplemental medical premiums are the town's responsibility if the court is not going to put them to the same town-paid health benefits as active employees. However, if the town does put them to the same town-paid benefits as active employees, our damages are greatly reduced. I think I said 17,000 and something by my calculation at the time I wrote the brief. So, and finally, I find it disturbing that Emmett Hibson ran roughshod over the town. The town has never cited any formal written change to the agreement or any policy to the agreement, anything that went by the Board of Mayor and Burgesses if they have one. This guy just said, we're cutting Mr. Gallagher and his wife off. And it was it was a complete year after he turned 65. So there's nothing to force him over there when he turned 65. It was just an assertion by Emmett Hibson at trial, and a ridiculous one. So with all due respect, first I would like this court to move my client to town-paid health insurance, which would limit his damages to Medicare premiums paid from the time they forced him there until the time of your decision. And if the court does not move him to the same town-paid health insurance as active employees, then to uphold the trial court's decision and find that the 85-87 collective bargaining agreement does apply, and there's no language that requires Mr. Gallagher to switch to Medicare A and B at age 65.
Justice Keller.
I just have one last question regarding your complaint that Medicare asked to be reimbursed when your client, I think your client collected some money or received some kind of a.
Yes.
Okay.
Third party.
And you're complaining about that, but we just had a case recently where a self-insured town now has the right to put a lien on any settlement or judgment that a town employee might receive, where the town is paid a portion or all of the medical costs incurred as a result of the injury or the personal injury. So when was this settlement received, or this money received, this award received by your client? What year, do you know?
I do. If you'll just give me a moment, I can find it. It's in my, I think I addressed that in my brief. I think it's at A.
Counsel, you have 5 minutes remaining.
Thank you, Your Honor. I believe it was Plaintiff's Exhibit 16 at A69. If I can get to A69, that'll give me the date of the approximate settlement. And yes, it was August 22nd, 2016. And in,
okay.
And in
Thank
response to your question, I know in my experience as a trial attorney that Medicare does get reimbursed and they don't always get reimbursed under health insurance. I don't know whether if the town had the type of insurance.
It's a state statute now. I just have to check the effective date because that claim may be a wash because the town might be able to turn around
I appreciate
and
that.
ask for reimbursement on that. Okay, thank you.
Thank you, Your Honor. Well, they didn't pay him for that, by the way. They never paid him for that $5,000.
The
Just
town did. I know, but Medicare sought reimbursement. And
well,
the
yeah,
town,
that came out of
towns can now put a lien and seek reimbursement on judgments and settlements if the town paid. So I guess what I'm saying is even if you were supposed to be on the town benefits at the time, the town might have been able to seek reimbursement.
And while that's correct, that wasn't part of the trial judge's award. The trial judge's award was limited to premiums from the time they forced him in July to Medicare until the date of the conclusion of the trial. So, well, the 5,000 and something, that was just evidence that he had to pay Medicare back because they forced him over to Medicare. That was never awarded by the trial judge. And I knew at the time that some health carriers don't seek reimbursement, so that's why I alleged that at the trial. And if the law is as Your Honor states it, and I'm sure it is, then that claim would not be accurate. So any award by this court would have to be reduced by whatever number that is.
Thank you, counsel.
Thank you, Your Honor, and thank you for your time. Unless there are more questions, I conclude.
Thank you. You're welcome, counsel. Attorney Krieger.
I just wanted to make a couple of points. I disagree with Attorney Ward that the collective bargaining agreement requires the same exact benefits. If you look at the language, and this is on page 50 of the appendix, it says that retirees and their enrolled dependents shall be entitled to town-paid health insurance coverage. It doesn't say to the same town-paid health insurance coverage as active employees, and it very well could have. So I think that the benefits have to mirror each other, but I don't think that the coverage has to be exactly the same under the collective bargaining agreement. I'd also like to say that we are not relying on that subsequent collective bargaining agreement.
Thank you, counsel. This question from Justice Sacker.
Yes, Your Honor.
I'll make it quick because I don't want you to lose your train of thought. You were starting a new point. I would say this. I don't know if it matters to this case or whether it mattered to the trial court. It's very troubling to me anyway that is it Cheryl Turner signed as the employee on this form? And is there any authority for that at all? I mean, I understand that the federal government either didn't notice it or didn't care, but it strikes me as highly irregular. Do you have any justification for that at all in the law or in any authoritative source where I could sign on behalf of my employee? Or I think the question's clear.
Ms. Lynch testified that this was something that she did on a regular basis, and so she had that authority.
Well, maybe that makes it worse. I mean, but so you don't have any form or federal regulation or other basis for saying that an employer can sign and submit an application like this on behalf of an employee. Is that correct?
That's correct. My other point was that we're not relying on that subsequent collective bargaining agreement. We're relying on the one that was in effect at the time of the plaintiff's retirement. Attorney Ward referred to the subsequent collective bargaining agreement not requiring premium payments. I don't think that that is applicable. I think it's what was in that first collective bargaining. That's all I have.
Thank you very much, counsel. With that, we will call this matter to an end, and we will adjourn until tomorrow morning. I want to thank council for participating in doing these arguments virtually. We really appreciate it. It actually helps not just the branch out, but the people of the state of Connecticut, because we're moving our docket forward, and I think that's extremely important, especially during these troubling times. So thank you, council. We greatly appreciate it. We are adjourned.
Thank you
I
very
will
much.
see the
Tom.
you're welcome. I will see the justices in the virtual